this morning's docket, case number 109706, State of Kansas v. Fisher.
May it please the Court, Samuel Shire of the Appellate Defender Office, appearing on behalf of the defendant appellant, Matthew Fisher. Your Honor, may I please reserve 3 minutes of rebuttal argument?
3 minutes is granted.
Thank you, Your Honor. Unless this Court would desire otherwise, I intend to address the issues in the order in which they were petitioned. I intend to submit Issue 6, the Ivory issue, on the brief. The seventh issue in the petition is a Murdoch illegal sentence issue. Given this Court's ruling in State v. Keel, unless this Court has particular questions about that issue, I would submit that on the briefing in the 609 letter. Moving to Issue 1, I believe that the State committed a Doyle violation during its cross-examination of Mr. Fisher. Per Doyle, and this Court's cases interpreting Doyle, a prosecutor may not impeach a defendant's testimony by implying that he or she had a post-Miranda pretrial obligation to divulge the substance of his or her testimony. And that's exactly what happened in this case. The prosecutor in this case closed his his cross-examination of Mr. Fisher by commenting, "When you were aware that maybe you didn't quite tell police exactly what happened, did you ever contact police and tell them you needed to talk to give a more definitive statement about what happened, what happened that night?" At that point, my client responds, "No." The State follows up, quote, "Never said a word about these things until today," end quote. At that point, we have an objection from trial counsel. And I think particularly with respect to the State's last statement, "never said a word about these things until today," this case is quite similar to State v. Kimball. The prosecutor in closing argument put up a slide saying he never said he was too drunk to remember, quote, "until today." So in both cases, this case and in Kimball, we have a prosecutorial effort to use a defendant's silence after receiving Miranda warnings up until the very day of trial as something that it would like the jury to make an adverse finding on credibility. And so for that reason, we believe that is a Doyle violation. And finding otherwise, the Court of Appeals viewed this as more of a comment on the inconsistencies in Mr. Fisher's statements that he made to police and in his testimony. And we would agree with the Court of Appeals that certainly a prosecutor can point out the inconsistencies that a defendant makes in his statements to police in his trial testimony. And in fact, the prosecutor did that quite thoroughly in his cross-examination. Defense counsel did not object until the prosecutor in this case commented, "Why did you not divulge the substance of your testimony to law enforcement until today?" And I think that's the clear-cut Doyle violation.
Why is it reversible?
Pardon, Your Honor?
Why is it reversible?
It is reversible because the evidence in this case, as far as intent to kill, was not overwhelming. There was obviously an altercation between Mr. Fisher and the victim in this case that resulted in great bodily harm. I think it's fair to say that Mr. Fisher was behaving quite strangely at the time of his arrest, after his car accident. I think a reasonable jury could look at the evidence in this case and reach the conclusion that it could have no idea what was possibly going on in Mr. Fisher's mind. And given that, his statements that he did not intend to kill the victim in this case, the credibility of those statements was impeached by the prosecutor's Doyle violation.
Just the severity of the injuries alone isn't enough to be overwhelming evidence on intent to kill?
In some cases, it could be, Your Honor, but when we look at the particular evidence in this case, there was a significant amount of evidence demonstrating that Mr. Fisher seemed to be in a delusional state of mind. And so this is not a case where a person who has rational thoughts inflicts a severe beating. Given that Mr. Fisher did not appear to be rational at the time this offense occurred, I don't think that a jury would necessarily find, from the extent of the injuries in this case alone, that there was an intent to kill.
But as you point out, the prosecutor did a very thorough job of pointing out all the inconsistencies and really had attacked the credibility of your client. So why did this one more question really tip the scale?
I would say it tipped the scale because Mr. Fisher testified that he did not intend to kill. And the prosecutor, by making this comment, is asking the jury not to infer that the story is different, his testimony is different than the statements he initially made to police. It's asking the jury to make some kind of inference that Mr. Fisher is deceptively hiding evidence, that he's not trustworthy. And I think that finding of trustworthiness, particularly with Mr. Fisher's comments that he did not intend to kill in this case, were basically what the verdict hinged on, I believe.
The Court of Appeals, as I read the decision, predicates their finding on the Doyle claim on their reading of the record and their statement that the record contains no evidence that your client ever invoked his right to remain silent. So I have two questions. One, do you agree that the record doesn't contain any evidence that he invoked his right to silence? And if that's true, how can there be a Doyle violation?
Well, Your Honor, to answer the first part of the question first, there was a first appearance in which Mr. Fisher was reapprised of his right to remain silent, and afterwards he requested an attorney. So perhaps that could be considered an invocation of Miranda. But more to the point, I don't think that to establish a Doyle violation, you have to establish an invocation of Miranda. What you have to establish is the reading of Miranda rights and an exercise of silence. I'm not aware of any case law from this court that indicates that there must be an invocation.
Well, the decision in State v. Parks is what the Court of Appeals relied on, and it describes a Doyle violation as an impermissible comment on a defendant's silence, and I'll quote here, after the defendant, quote, instead invoked his or her constitutional right to remain silent.
Your Honor, I think in Parks, what it was decided is that the statement that I don't want to make a comment on camera was admissible for the purpose of demonstrating why the defendant did not have a taped interrogation. I know that language is in there. I don't think that's central to the holding. I think that's loose language in the opinion.
Okay.
As far as I'm aware, there's no... Yes, Your Honor.
We don't have any cases that indicate how that invocation has to occur, do we? If you just quit talking and don't say anything more, isn't that an invocation of your right to remain silent?
I'm not sure it would be an invocation of Miranda. It would be the exercise of the right to remain silent. And that's all this court has ever required. And if this court goes back to Doyle, it doesn't refer to the invocation of Miranda rights. It refers to the exercise of the right to remain silent.
So after appointment of counsel, he never said anything more about this episode until the trial. Is that right?
That's correct, Your Honor. Moving very quickly to the prosecutorial misconduct issues, in this state, the prosecutor, in his rebuttal argument, commented that Mr. Fisher's testimony, particularly the aspects of it pertaining to self-defense, was bold. And I don't see how the Court of Appeals got around Elnicky in determining that those statements were proper. In Elnicki, this court recognized that referring to a defendant's statement as bullshit is the same thing as saying that a defendant is lying. We have basically the same comment here. The prosecutor said that Mr. Fisher's testimony was bull. We believe that's misconduct. In fact, we think it's so obvious that that is misconduct that it is gross and flagrant and demonstrates ill will. For the reasons argued before on the Doyle issue, we also believe that the evidence in this case is not overwhelming and that the prosecutor's error requires a reversal of Mr. Fisher's conviction. Moving very briefly to the jury instruction issues, I want to focus on the instruction or the non-instruction of the district court on attempted voluntary manslaughter. As the Court of Appeals recognized, I think the facts in this case would support a finding that Mr. Fisher, quote, appeared to be delusional and wholly detached from the reality of the circumstances surrounding the severe beating that he had inflicted upon Angel. I think that's a fair reading of the evidence. Particularly, we think a jury could have found that Mr. Fisher believed that he was fighting with an assassin when he was in fact in a physical altercation with Angel. Court of Appeals points out that in State v. Ordway, this court held that an imperfect voluntary manslaughter offense cannot be predicated upon a defendant's delusional psychotic beliefs. And we would respectfully ask this court to revisit and overrule Ordway. By statute, voluntary manslaughter offense is a killing of a human being committed upon, quote, an unreasonable but honest belief that circumstances existed that justified the use of deadly force. A delusion, by its very nature, is an honest but unreasonable belief. If a delusion isn't honestly believed, it's not a delusion.
Was there any expert testimony that he was suffering from a delusion at the time?
No, there was not, Your Honor.
Okay, and there wasn't a diminished capacity defense exactly, was there? Was this a diminished capacity case? Did they try it as a diminished capacity kind of case?
No diminished capacity defense, Your Honor.
Okay, he just said this is what I thought was going on.
His statements to EMT immediately after were that he had taken care of the assassin that had been sent to kill him.
And I know there was a test of the alcohol. Was there a test of the alcohol in his blood? Did he have was there any evidence about how much he drank?
I don't recall a blood alcohol content testimony.
Okay.
However, there was quite a bit of testimony of how much he drank that day.
Right, about consumption, but no testing that you can remember.
Not that I recall, and I'm not saying it's not there, I just don't recall at this time.
Does this have to be an Ordway case? Do we have to be at the delusional level in order to be entitled to that instruction?
No, I think that you could. Mr. Fisher testified that, well, particularly his trial testimony was that he was being attacked by Angel and he thought his response was a proportionate response to her attacks.
Yeah, he definitely had an honest belief about possibly she was an agent or these cops he'd seen on the way home were agents of the government or whatever. I mean, there was weird stuff going on in there, there's no question. So he certainly had plenty of evidence of an honest belief. But I guess my query is, do we really have to get to Ordway? Because does instruction of attempted voluntary manslaughter require that your belief be so objectively unreasonable that it's delusional? Or isn't there some light between there?
Well, I think that perhaps a jury could have reached a conclusion that Mr. Fisher, there was a lot of different statements made in this case, which makes it, but a jury could have found that Mr. Fisher was not delusional, but still found that he was honestly mistaken about the circumstances surrounding.
Honest and objectively unreasonable.
Yes,
I mean,
Your Honor.
it's a two-part test, so putting aside the subjective part of it, the objectively unreasonable, it just seems like a person can arrive at an objectively unreasonable belief without being crazy.
Right, Your Honor. Yes, Your Honor. Absolutely.
Thanks.
Well, the problem with Ordway was it it's a little contradictory because it said that there is no objective prong, that it's simply subjective, but then determined that you don't apply it if it's a delusional, psychotic belief, which is a little contradictory. I think we talked about that in Roeder. And in Roeder, we said the second prong is whether if what was believed would have been a defense, if accurate, then you get the instruction, wasn't it?
That's, yes, Roeder, Your Honor. And I think under Roeder, an instruction should have been given in this case.
But it wasn't requested. And so you have to firmly convince us that the result would have been different.
Yes, Your Honor.
And that is why.
And that is the statements that Mr. Fisher made immediately after these events occurred was that he thought an assassin was attempting to kill him and that he had taken care of her. And I think that those are the statements that a jury probably would have relied on and found that Mr. Fisher had a completely unreasonable but honest belief that would have warranted the use of or justified the use of force.
Could I clarify something that on the Doyle violation, you mentioned that defense counsel interposed a contemporaneous objection. That was overruled, wasn't it?
The objection was overruled, and the prosecutor did not re-ask the question after the objection was overruled. I think primarily because it was essentially a rhetorical question, more for the benefit of the jury than to get an actual response.
Which was this again? Which comment was this, the objection?
The objection was made, never said a word about these things
yeah.
after today. Okay. Objection overruled. Prosecutor doesn't re-ask the question.
Thank you. I just need to be reminded.
Any further presentation?
No, Your Honor.
Any more?
I'd like you to address cumulative error, if you would. Because you've alleged multiple errors here. So do you have an argument that you'd like to make today on cumulative error?
Yes, Your Honor. Particularly with respect to the clearly erroneous standard that we're on the jury instruction, when you throw that into the cumulative error analysis, I think that becomes a more favorable standard of reversibility for us because we have asserted and I think established constitutional error in this case. And again, I would just emphasize that Mr. Fisher's thoughts were so scattered that it would have been incredibly difficult, I think, for a jury to make a determination about what his mental state was. And for that reason, the state's evidence of an intent to kill was weak.
Any further questions? Thank you, counsel.
May it please the court. I'm Jonathan Noble. I'm with the Lyon County Attorney's Office. I'm arguing the cause of the plaintiff appellee today. Unless the court would prefer otherwise, I would like to start off addressing counsel's arguments as far as the jury instruction, then move on to the alleged Doyle violation, and finish with the arguments regarding misconduct. Specifically, in regards to the jury instruction, the instruction was not requested, and so the appropriate standard of review here is whether, in the light of the entire record, this court is firmly convinced that a jury would have found differently. The Court of Appeals found that the reviewing court is not able to speculate that a jury could have or might have been. The question here is, would they have found differently? And the state would submit that based on the overwhelming evidence that was presented, including the extensive injuries to Angelique Worthen, the testimony of both Angel Worthen, the evidence that was found at the crime scene of the vicious attack, and the testimony of Timothy Worthen concerning finding the damage to his porch the day after the event was happened, would not lead a jury to come to a different result.
So the vicious, pretty much all of that's about the viciousness of the attack, or
That's-
the extent of the injuries. Do you have any other evidence you would point to that should lead us to conclude that this was not clearly erroneous? Because you named three things, but they're all kind of the same thing. How significant her injuries were, the evidence at the scene that corroborated how significant her injuries were, and possibly viciousness, which is more of a intentional idea, and the damaged porch, which again has to do with how bad her injuries are. Is there any other aspect of the evidence you'd want to point us to on that?
I would point you back to Mr. Fisher's own statements that were given prior to trial to law enforcement, the three different accounts that he gave, first to Officer Jeffries and Officer Serrano, saying that he killed the assassin, that he beat that, and I'm not going to repeat the word. Then he gave the account to Sergeant Ray Mattis, indicating that he grabbed her by the throat and pushed her down and stomped on her. He indicated at that time that he did not intend to kill her, however, and then mentioned that it was about self-defense. However, when he was interviewed by Detective Kay Olemeyer, he did not specifically say anything about self-defense. Indicated that he had hit her multiple times. And I try to keep each story straight, but unfortunately I'm not exactly able to refer to which is which in which account.
So let
But the
me see if I understand what you're saying, though, about those various statements. It seems like if he's talking about having assassins after him, that he was acting in self-defense, that those actually contribute to the factual appropriateness of the attempted voluntary manslaughter, imperfect self-defense. Is what you're trying to say that the three statements that you've been through so far are inconsistent and therefore he's not believable?
Yes, Your Honor.
Okay.
That is exactly what I'm saying.
Are you conceding that it's error? I mean, you're asking us to go to the harmless analysis. I assume is that your position here, that it's error? Was
Your
it
Honor-
error not to instruct?
Your Honor, the state maintains it was still not error based on Ordway. However, the Court of Appeals never reached that. They never reached a factual decision about whether or not it was error or not. Or they just said in any event, we aren't firmly convinced that a jury would have done something differently had the non-requested instruction been given. And therefore, they never made a determination on whether or not Ordway applied or not. They did make comments about the bizarre nature of his testimony. It's still the state's position that Ordway indicates that someone who is under the effects of a psychotic delusion is not entitled to that instruction anyway.
And so it's the state's theory that he was functioning under a psychotic delusion? And if so, why doesn't that corroborate the no intent to kill rationale for voluntary manslaughter? I mean, that actually helps the defense if you're arguing that he was operating under a psychotic delusion, doesn't it? Or what am I missing here?
Justice, I don't really think you're missing anything. It is somewhat of a split argument, I would admit. Really, the state's position is that not only was there not error, but it was not clearly erroneous based on the harmless test. That's really what I'm hanging my hat on here today, that a jury would not, that we can't engage in speculation given the light of the entire record of the evidence that was presented.
And how do you respond to opposing counsel's argument that it's a pretty high bar on clearly erroneous that we've established that to firmly convince us that the jury would have done something different. But that when you couple that with other errors, then it lowers the bar to the cumulative error test. Would you agree with that? That even though we would have to be firmly convinced that it would change the trial in order to reverse on the instruction, we can consider that as part of the calculus under the denial of fair trial test of cumulative error?
Your Honor, my response is yes, that if it's part of the cumulative error analysis, yes, it could be considered as part of that analysis. However, one error in itself is not enough to reverse under cumulative error test. Turning back to the Doyle issue, unless anyone has further questions on the instruction issue.
Counsel, I'd like to ask a question about the threshold question of whether there was error at all in not giving the instruction. You've made that conclusion for us today. What is the legal standard that you would be applying to come to that conclusion?
Your Honor, if I may take a moment.
Sure.
Your Honor, the clearly erroneous standard, my apologies, was set out under...
I'm not talking about clearly erroneous. That is assuming there was error, it was not clear error.
Mm-hmm.
I'm going back to what I understood you to say earlier, and that is we're not conceding that there was error at all. So what is the basis for you to conclude there was no error in not giving this instruction for attempted voluntary manslaughter?
Your Honor, the standard for whether or not there was an instruction should have been given was whether or not it was factually and legally appropriate. Specifically, if there was some evidence would reasonably justify conviction of the lesser included crime. The evidence does not have to be strong or extensive as long as the jury might reasonably infer the lesser crime from that evidence. Under Martinez, the court is required, absent an objection from defense counsel, which there was, this simply wasn't requested at all, that they must give an instruction even if the evidence is weak, inconclusive, and consists solely of the testimony of the defendant.
You've given me the legal standard you're relying on. Thank you.
All right.
You were going to move to the Doyle violation now?
Back to the Doyle violation. Your Honor, the standard for Doyle was whether or not the prosecutor attempted to piece the truth of the statement by pleading had a post-arrest obligation to divulge the substance of his trial testimony. As we had previously discussed, Mr. Fisher gave 3 different accounts of what happened prior to trial, and then 4 different accounts of what happened after trial. There was nothing in the record to indicate that he ever affirmatively invoked his right to remain silent. The first question
Is that, counsel, is that a prerequisite for finding a Doyle violation?
Your Honor, I'm not aware of...
Invocation of the right to
I'm
remain
not
silent.
aware of any specific case that require that to be a specific prerequisite.
That's a little contradictory, isn't it? That you have to affirmatively state that you're going to remain silent? Why can't you exercise your right to remain silent by remaining silent?
It is, Your Honor. I would agree. The first comment, the Court of Appeals, or the first remark, the Court of Appeals talked about, they found to be an accurate comment pointing out the inconsistencies of the statements. The second question that was asked as a follow-up that was objected to was never followed up with again in the entire trial.
So are you saying that the objection on the first comment wasn't sufficient because your client answered faster than the prosecutor got to his feet? Is that your argument?
No, Your Honor, I'm
So-
representing the state, so I'm not representing.
Are you
Well,
saying
I'm
there,
at-
there wasn't
yeah,
an
I'm sorry
objection
that-
on it? There was not an objection on the first question, so
Yes, Your Honor. It was answered prior to the objection, and there was never really a specific objection on the record. The defense counsel argued that this infringes his constitutional rights, did not make
but
a
it was
specific.
sustained on the second question.
Well, there was never an objection on the first question.
That's what I'm saying. And then the second question, there was an objection.
There
You're
was an
saying that wasn't
objection.
very specific, but it was nevertheless sustained, and then the prosecutor didn't return to the subject matter, right?
No, it was overruled.
Did you try this case?
No, I did not.
Okay.
It was not. It was overruled, and the prosecutor
Overruled,
dropped
okay.
the question, moved on, and never went on again. Never referred back to it again.
Okay.
That's significantly different from the analysis in Kimball, where the prosecutor, and I believe it was under a prosecutorial misconduct standard of review, put it on intentionally put it on a slide and made it part of their closing argument. Drew additional attention to that fact.
But isn't the point of the question fulfilled by the asking? You don't need an answer to that question for the prosecutor to make the point to the jury that he's telling the story today, but he didn't take an opportunity to tell the police this before. And so the very asking of the question actually puts that improper thought in the jury's head, doesn't it? I mean, the fact that the prosecutor never pushed for an answer, which everyone knew was no, doesn't really affect its harm that I can see. I mean, you've already poisoned the well, as it were, with the question. You don't need an answer. So I'm having trouble seeing why that makes a difference that the prosecutor didn't press for an answer.
Your Honor, I'd ask the court to look at Mims that was cited in the brief, where the only distinguishing matter on that was that the judge sustained the objection, but did not give a limiting instruction alongside of it. So the question, the poisoning of the well, to be characterized as out there, it was not emphasized in the trial. And looking in the light of the overwhelming evidence that was presented at trial, I would ask the court not to reverse on that issue.
I'm a little confused. Are you arguing the harmless on that, or are you conceding a Doyle violation by walking into this field with the question?
No, Your Honor, we're not conceding that a Doyle violation happened. The state still maintains, as was briefed, that the issue wasn't properly preserved by a specific and timely objection, and that since the question was never answered, and questions by prosecutor or by counsel are not evidence in of themselves and never revisited, it was not in fact an error.
This might seem trivial in light of the violent and serious nature of this case, but since we're potentially looking at cumulative error, what is on the criminal damage to property, which was somewhat extensive on the porch anyway, in the door, what is the ownership interest of Angel Worthman? She, as I understand the facts, is that she is the former wife of the owner of the property, and she lived there. It's not real clear, but what interest does she have in the property to make her the victim of criminal damage?
Your Honor, my understanding of the brief was it was briefed that she was a renter, but the evidence indicated that she was a former wife, that it had been transferred to.
Well, you
Mr.
glossed over,
Gordon.
is she a renter of the property, or she just lived, that's
She,
what,
she,
it
she
wasn't
lived
clear.
there. The record is silent on what her exact status was, except that she resided there, that she was
Is that
receiving
enough,
mail.
is that enough to have her have an interest in the properties to suffice to make her a victim of this crime? I mean, it'd be pretty clear if the owner of the property, who is also part of this case, was the asserted to have the ownership interest, but does she?
Your Honor, the standard for insufficiency is in the light most favorable to the state, whether a reasonable fact finder could find from that information that a property interest, not an ownership interest, but a property interest existed. And therefore, in this case, they found out, and I believe the criminal damage specifically was to the porch as well as the door.
Yeah,
and
I think it was all on the
property.
not any items specific to her.
And even if she wasn't paying rent, Your Honor, she was living there, and a person living there would still, in the light most favorable to the state, have a property interest.
Let me turn that around. Did she have the authority to consent to the damage to that door? Or did she have the authority to tell someone to come in and cut a hole in the door and put a plastic over it, whatever? It seems to me if she's harmed by the damage, that means she has some control over it. And it's hard for me to see how a gratuitous resident of the house would have that harm if they don't also have the authority to consent to damage. You understand what I'm saying?
I understand, Your Honor. I recall that the testimony by Ms. Worthen is she did not consent. And whether she was gratuitous or not, she was there at the behest of Mr. Worthen. And therefore, and although it was not briefed, and I'm somewhat limited in the procedural posture of this case, she would be under the same situation as a social guest. And since it appears, I'm out of time, it also appears that the court is looking at this from a cumulative error standpoint. If the court wishes me to make any comments to that regard, I'd be happy to do so. Otherwise, if there are no specific questions on that standard and why the state believes that there should not be a reversal under a cumulative error standard, I'd be finished.
We've,
Excuse me, I'm sorry.
no, I was just going to say, we've taken a lot of your time with questions. If you would like to give us your presentation on why cumulative error does not warrant reversal, I'd be open to that. Was that very good?
Your Honor, under State v. Smith, cumulative errors, when considered collectively, may require reversal of defendant's convictions when the totality of the circumstances substantially prejudiced the defendant and denied the defendant of a fair trial. The state still maintains that there were no errors, and the Court of Appeals agreed with that. The court is to examine errors that it finds in the context of the record as a whole, and consider how the district court dealt with the errors, but however, most of these weren't addressed at the district court level, and I would concede that most of these were raised on the appellate court level. And the court can consider the nature, the number of errors, their interrelationship, and the strength of the evidence, and that standard set forth in State v. Tully. In Pennington, when the record in light of a whole fails to support that the confidence in the trial process was undermined, then not only even one error is sufficient to require reversal. Therefore, Your Honor, I ask the court to affirm the Court of Appeals decision and the conviction of Mr. Fisher.
Any more questions?
Just to clarify, the strength of evidence, here, really, we're talking about strength of evidence of intent to kill. Would you agree with that?
I don't know if that specific, you can narrow it down to that specific issue. I think it's the strength of the evidence of the entire case and the entire trial as it was presented.
Any more questions? Thank you, counsel.
Thank you.
You're reserved 3 minutes for rebuttal.
Your Honor, at this time, I'm prepared to conclude argument. However, if this court has any further questions, I would like to entertain those at this time.
Questions? I see none. Thank you. We thank both counsel for your arguments this morning. Court will take this matter under advisement.